He laughed the moment she walked through the courtroom door. A short, dismissive burst that rippled across the wood-paneled room and landed like an accusation. "You're wasting our time." He laughed because she had come alone, because her suit was threadbare at the cuff, because everyone with power had assumed she would hire counsel or quietly accept the settlement. He laughed because his world had always told him which faces belonged in the gallery and which belonged in the courtroom proper. She did not laugh back. She set a worn briefcase on the row beside her, smoothed a folder until the edges lined up, and walked to the well with the kind of calm that is often mistaken for surrender. Her heels clicked once on the marble. They were the same sound a dozen times over in the years when she had been the one making the phones ring, scheduling the contractors, and rewriting pitch decks at 2 a.m. so his investors could believe the company had sprung fully formed from his head. Those clicks today were measured. They were marks of someone who had rehearsed steadiness until it felt like truth. He laughed when she walked in, the narrator said later, not as indictment but as fact. In the room, the laugh had been Damon Cross Morrison's, quick, practiced, the laugh of a man accustomed to other people allowing his narratives to stand unchallenged. He sat at the defense table flanked by 2 men in tailored suits. Gregory Whitmore, the lead defense attorney whose opening lines would be polished, precise, and cruel in their own civility, and a silent associate who took notes with a pen that never hesitated. Damon's posture was relaxed. The same man who had negotiated term sheets and toasted victories now wore the same taste for theater. Judge Patricia Okonkwo presided from a bench of dark mahogany that had taken on the soft sheen of generations of cases. She observed the room in the way of someone who had seen motions come and go, who knew the theater of litigation and the small, decisive actions that turned it. Cameras were not allowed in the courtroom, but word of the trial had already slipped into the press. There was a buzz outside that made this room feel larger than it was, not for the law, but for the story people wanted. The fall of a celebrated entrepreneur, the vindication of a wronged spouse. Kesha Darnell Morrison, 36, wore a navy suit that had been the color of her hopes. Threads at the cuff betrayed the many times it had been repaired by hand. A faint ink stain crossed the left knee like a small map of the nights she'd spent drafting contracts on legal pads. Her hair was pulled back. Her hands trembled when she reached for the folder, but the tremor steadied into a deliberate, almost ceremonial motion as she laid the documents before the court. The first pages were crisp, not because they were new, but because memory and careful copying had made them so. The case had never been about melodrama. It was about the erasure of labor that no one had thought to value. Damon's name sat atop press releases, on websites and investor decks. But the records Kesha held would tell a different story. A story of hours logged, of introductions made, of a business plan drafted on napkins at breakfast and formalized with an SBA application that listed her as co-founder. There would be bank statements showing a $47,000 transfer labeled personal loan that never made it back to her account. There would be emails to Julian Cortez, an early investor, where she had negotiated terms and chased signatures while Damon charmed the rooms. And there would be formation documents, the safe technical things like articles of organization, that bore witness to the arrangements neither of them had publicly acknowledged until now. Whitmore's opening was clean and economical. He painted Kesha in the language of opportunism, a woman who had waited too long, who suddenly noticed her name was not in the column she expected, who had decided that litigation was preferable to compromise. He spoke of business razors and marital acronyms as if they were whole explanations. Community property, he said, as if that phrase could be lobbed without showing what it meant. For the lay listener, community property is simply the pool of assets acquired during a marriage that the law treats as jointly owned, unless there's an agreement or evidence otherwise. Whitmore relied on its vagueness. He hoped people would see a wife stepping out of step and assume greed where there might only be truth. When Kesha rose, the room shifted. Her opening statement was not rehearsed for theatrics. It was a ledger of small, stubborn certainties. She did not shout. She did not beg. She said simply, "I didn't just support him, I built him." The words landed like a set of facts, not accusation but declaration. Her voice carried the years of invisible labor, the endless administrative work, the first customer calls, the spreadsheets with names that later became titles, the nights she had converted her own savings into a loan so payroll could be met. She opened the folder with hands that had once jittered with anxiety and now moved with the calm of someone who had been through 1,000 small deaths and decided to keep living. The folder contained a copy of an SBA business plan where her name was listed as co-founder, a PDF of emails to Julian Cortez where she had pitched early valuation and asked for a seed wire, and a bank ledger with a line item, $47,000, personal loan to company, no repayment trace. These documents were not explosive in the tabloid sense, but they were irrefutable to anyone who could read numbers and dates. A witness list followed. The first to take the stand was Isaiah Tomaine Wallace, a senior network engineer who had been brought on in the early days to build the product that would later be free up the headlines. Isaiah's testimony was plain and unadorned. He remembered Kesha's name from the onboarding emails. He remembered that when the product went live, she had been the one fielding the technical calls from early adopters, staying up to patch servers at dawn. He was not a man given to drama. His proof was the email chain that showed Kesha's directives and the timestamps that matched late-night activity. "You were copied on an email where Ms. Morrison asked for the production server reboot?" Kesha asked. Isaiah nodded. "Yes." "And who did that email come from originally?" "It came from Kesha. She was the point of contact." The court heard a small, steady murmur, the kind that registers as a shift in the room's gravity. Whitmore had framed this as a late-career litigation sparked by misperception. The evidence said otherwise. A few lines of metadata and the recollection of a technician who had been awake at 3 a.m. because someone had asked him to hold the line for a patch were enough to start bending the narrative. Camille Renee Booker followed. She had been a business partner in a short-lived collaboration before Kesha and Damon set up the formal company. Camille's testimony introduced another kind of proof, a draft of a partnership agreement where Kesha's role had been explicit, and a contemporaneous note in which she referred to Kesha as the de facto chief operations person. Camille's words were the kind of corroboration that nudges a judge from doubt to curiosity. Damon's smirk thinned with each document the court read. "Pride is an efficient thing. It makes men believe the world owes them a benefit of the doubt." Whitmore's earlier assertions, sharp as they were, couldn't erase paper. Paper doesn't care for charm. The audience in the gallery, observers, a couple of journalists, a group of friends in quiet suits, leaned forward like a collective ear. The cross-examinations were controlled and clean. Kesha did not speak in rhetorical flourishes. Instead, she asked simple questions that required simple yes or no answers. She knew the records better than anyone in the room. She had lived with them. When Damon took the stand later that morning, his defense was a practiced denial. He remembered the partnership differently. He assumed certain payments had been loans that were repaid. He offered the kind of fuzzy recollection that thrives on the absence of records. Kesha had decided not to be represented at the outset. This decision had been framed by opponents in whispers, reckless, naive, and in the press as a curiosity. But for Kesha, it had been a deliberate choice born from necessity and preparation. She could not afford a top-flight attorney, and had felt that no one would tell her story with the care she required. The risk was enormous. The benefit was the possibility that her voice would not be filtered, that every word she chose would have the intended fidelity to the facts. When Damon was asked about the $47,000, the exchange that followed was the first small crack in the facade. "Do you recall receiving a transfer marked personal loan to the company in January of 2017? Kesha asked. "I don't remember that transfer specifically," Damon said. "Do you have records that show a repayment of that exact sum to Ms. Morrison?" A lawyer's reflex is to parse memory, to create room between an admitted fact and responsibility. Damon shifted. Whitmore whispered something brief into his ear. The defense's strategy relied on gaps. The absence of a check with her name, the lack of a clear ledger entry going from company to individual. But Kesha had anticipated that. The bank statement she showed was not her memory alone. It was a ledger that showed the outgoing transfer and, crucially, an absence where a repayment should have been. Numbers refused to be evasive forever. The judge intervened gently, reminding counsel of rules, but the tenor of the morning had changed. The energy in the courtroom, earlier brittle with skepticism about a woman representing herself, now felt like a slow recalibration. People were not yet rooting. They were listening. That is the victory of proof. Not the immediate roar, but the silence that follows, the listening that begins to gather, like rain clouds swelling over a long drought. Between witness statements, the camera in the hallway, not a camera in the room, but the world outside, would tell a different story. Reporters jotting notes, ex-partners whispering, the world beginning to reframe a familiar narrative. But inside the courtroom, the story was being remade with quiet precision. Each page she turned, each email she read, dissolved a piece of the carefully assembled myth. It was during a mid-morning recess that the stakes of small personal choices surfaced in the most human way. Damon left the room with Whitmore and his associate, heads together, a little click of strategy. Keisha stayed, hands now steadier, for the time being content to gather herself and the next set of documents. As people filed out and the courtroom emptied to a hum, one of Damon's associates paused near Kesha's table. His voice was low, the kind intended for ears and not recorders. "Look," he said, "this could be settled. Your client—" "I'm not his client," Kesha said. Her voice was measured. She knew how offers were designed. They were tiny traps, quick cash for long silence. For many, the temptation is immediate. For her, it was another test of what she was willing to trade for what had been taken. The associate offered numbers and hints of confidentiality. Damon, who had been watching from the hallway, leaned in. He spoke not with anger, but with a practiced dominance that had often dissolved inconvenient problems. "We can make this easy," he said to her, as if kindness could be a kind of obliteration. Kesha declined. The word was small, but in it lived a steel forged behind closed doors. Her refusal was not dramatic. It was pragmatic and exacting. She had sacrificed a lot to get here, including a sense of ease in the world. She was not going to sell that thinly now. Outside, as the hallway filled with the shuffle of legal pads and the clack of dress shoes on marble, a woman watched from a distance. Yvonne Baptiste had the bearing of someone who had learned what courtroom fights could look like and the scars they left behind. She was not there for reasons of vanity. She had been in the trenches herself years before, a young attorney who had once stood pro bono for a woman with less and changed a trajectory because she decided to lean in. She'd come to observe, to see the kind of fight that deserves public attention. Yvonne had noticed Kesha's quiet competence, the way she controlled a room with documents instead of theatrics. She had also noticed the dismissal, the laugh, the assumptions, the easy faith in narrative that privileged Damon because of his polish and connections. She had watched Kesha refuse the settlement offer with a particular kind of clarity, the kind that sometimes signals a person has one weapon left: truth. For days before the trial, Kesha had prepared in private. She had done what those without resources often must do: become their own archivist and their own counsel in the most literal sense. She had pulled records from old emails, copied bank statements, reconstructed a trail of communication with vendors and investors. She had found an old printed business plan from an SBA filing that included her name as a co-founder, though that document had never been part of the public package. She knew the significance of formation documents, the technical filings that create a business entity, and that those documents often carry the fingerprints of intent. If her name was on early formation filings or in operating agreements, then the narrative of erasure would need to grapple with recorded reality. Kesha's preparation was not mere tenacity, it was a translation device. Where emotions could be dismissed as subjectivity, a bank entry or a dated email could speak with juridical conservatism. She had learned the language of evidence because she needed the law's cold grammar to make her warmth legible. That afternoon, as the morning witnesses finished and the gallery thinned, Isaiah waved at Kesha with a nod of solidarity. Camille stayed to exchange a few words, her eyes tired but resolute. The momentum had shifted, but the trial was far from decided. Whitmore retreated to his table like a chess player re-evaluating the board. Damon sat with the kind of expression people wear when a comfortable script is being interrupted. The harder puzzles remained. Why had Damon arranged for a transfer named as a loan and then produced no repayment evidence? Why had his public image so thoroughly eclipsed the operational labor that made the company function? And crucially, what other papers lay buried in corporate filings and offshore shells that could tell the fuller truth? When the court reconvened, the day brought the first direct confrontation on the stand. Damon, taking the oath, was calm at first. He spoke with the assurance of someone who had everybody assume his memory would be believed. He called back to the old days with a practiced nostalgia, using terms like "we" and "our team" in the way that claimed broad credit while obscuring granular responsibility. Kesha's questions were the opposite of theatrical. She asked specifics. Who signed the SBA application? Who handled the negotiations with Julian Cortez? When was the personal loan recorded as repaid? The answers came back as practiced non-answers until paper intervened. When she held up an email chain to the court and asked if Damon recognized the sender's address and the content, the judge permitted it into evidence. Under oath, words feel heavier. Image and charm give way to the velocity of direct interrogation. Damon grew flush on the stand. The more he tried to smooth over specifics with platitudes, the more the record tightened around him. A careful transcript of disconnected memory cannot overrule the crispness of dated emails and signed documents. Numbers and timestamps do not rely on charm. At one point, Judge Okonkwo leaned forward and asked a question that many in the room felt, but none had yet voiced aloud. Is there any documentation that reconciles the loan amount being repaid? The question did not indict. It opened a procedural path. Damon's defense wavered. Whitmore objected in a tidy, accustomed way, and the judge maintained order. But the substance remained. The ledger did not show repayment. The afternoon wore on. There were raised eyebrows and uncomfortable silences. There were whispers in the hall, of course, partly human curiosity, partly the hunger of a media cycle. But inside the courtroom, the work proceeded, document by document, witness by witness, the story reassembled not in flame but in fact. When the court recessed for the day, the outcome was not settled. The press outside jostled for angles. The friends and family clustered in small groups, trading worried glances and tentative smiles. Kesha packed her folder with the same careful motion she had used that morning, and she felt for the first time in months a tentative sense of being understood. That was not the same thing as victory. It was only the precondition. Proof being heard. As she stepped into the crisp afternoon, still carrying the gravity of the morning, a man approached her. Not Damon, not Whitmore, but an older partner from a local non-profit legal clinic. He extended a card with a soft, urgent tone. "I've been watching," he said. "There's more to be found, and we do this work to make sure the records get seen." Kesha took the card and looked at the name. Not a famous firm, but a network of lawyers with a reputation for following threads others missed. She remembered the man who had told her early on that she couldn't take the case pro se unless she understood documents. She had listened, studied, and still come here alone because she had felt no one captured the meaning the way she could. But there are moments when the tiny advantages of experts become necessary. That evening, after a sparse dinner eaten with the folder still on the table, Kesha sat at her kitchen counter and looked through the documents again. The presence of the $47,000 line was a small, bright presence on the ledger. The email to Julian bore language that was not flattery but negotiation. The SBA plan, yellowed at the folds, read like a map of what could have been if credit had been given where it was due. Each artifact was a claim of presence, a refusal to be erased. At home, she called a friend who had done accounting work for the company in the early days. The friend confirmed transfers, dates, and oddities. Transactions routed through accounts whose ultimate beneficiaries were difficult to trace. "Sometimes that happens when people prepare for divorce," the friend said, hesitant, without accusation. "Assets get moved around before papers are filed." Kesha's stomach tightened. The phrase divorce planning landed like a frost. Assets moved before filings. That was the sort of thing that could convert a fair division into a hollow victory. If money and equity had been shifted into entities whose paperwork omitted her name, the legal fight would be about more than a ledger line. It would be about chasing structure through layers of formation documents. She slept that night with the papers stacked beside her bed like cold witnesses. In the morning, she would return to court. The next phases involved more than testimony: subpoena returns, examination of formation records, and the patient work of tracing beneficiaries through formation documents and amendments. Formation documents, the articles, operating agreements, amendments, are the skeletons behind the skeleton of a company. They name members, beneficiaries, managers. They reveal intent or deceit. If someone had quietly amended a document to remove a spouse's beneficiary status or to move assets into Cross Holdings LLC, the trail would be technical but telling. Kesha had the grit to read them. She had also begun to learn the importance of having someone else look where the human eye might unconsciously grant gaps the benefit of the doubt. That is where mentorship fits into the arc of a case like this. Not as a magic wand, but as a second set of hands turning pages in a dimly lit archive and catching things that cost years of sleep to notice. When court resumed, the atmosphere was taut. Damon took the stand again, and the questioning found its rhythm. The defense tried to recast the personal loan as a corporate expense. Kesha insisted on clarity. The judge asked for more recent bank records to reconcile the amounts. Whitmore promised to produce them. The skirmish, like others in litigation, was both legal and human. No one wanted to be boxed in by paperwork that contradicted their public image. At mid-afternoon, on a recess where the courtroom emptied and the air felt like it could carry secrets, Yvonne Baptiste moved closer. She introduced herself with the kind of quiet directness that makes people either defensive or relieved. "Ms. Morrison," she said, "I was in a fight like this once. If you want, there's pro bono support we can put to work on tracking corporate formations and amendments. It's specialized work, but it makes the difference between a story and a verdict." Her voice had the cadence of someone who had seen a pattern enough times to recognize it by the sound it made. Kesha thanked her, guarded but aware that resources were scarce and that help could change the practical terrain of the fight. Yvonne did not promise miracles. She spoke instead of diligence, of subpoenas and formation searches, of how names can be tucked out of sight by amendments filed in jurisdictions designed to complicate discovery. She used the quiet, technical phrases with an economy that conveyed both experience and humility. That evening, Yvonne and Kesha arranged to meet outside the courthouse. They sat at a small cafe where the light slanted in like a stage cue. Yvonne unfolded a map of filings on her laptop, less a dramatic reveal than a careful parsing of public records. She showed Kesha a Delaware formation record that listed Cross Holdings LLC as a member of a holding structure. The kind of formation that separates a person's publicly visible assets from the corporate veins where equity can be shifted. People use holding companies for a lot of legitimate reasons, Yvonne explained. Sometimes it's protection, sometimes it's planning for taxes. Sometimes, and this is what we're worried about here, it's a way for one spouse to move assets ahead of a filing, or to centralize them in names that make recovery more difficult. Kesha leaned in. The words were technical, but the implications were operational. If Cross Holdings LLC had been created, and if amendments had been made that removed her as a beneficiary months before separation papers were filed, then the scale of erasure was intentional. It moved beyond omission to a pattern, anticipatory action to shield assets. Yvonne pulled up an amendment trail that, on the surface, looked innocuous. Timestamps flipped, signatures in the right places, but the substance was what captured their attention. The amendment that removed a beneficiary name had been filed 6 months prior to the divorce petition. The timing was the important axis. The amendment alone would not be conclusive. It would invite more questions. Who executed it? Under what authority? What funds were moved? And who benefited? But pattern, especially when corroborated by emails and transfers, builds inference. Yvonne did not promise that this discovery would be dispositive. She said instead what she had said to the young women she'd represented years before. "We follow the paper. Paper tells a story if we read patiently." She offered to take on the formation search pro bono, and to assist in drafting targeted subpoenas that could compel the production of bank reconciliations and beneficiary lists. Her offer was not grand. It was a pragmatic next step, the kind that turns a precarious case into a methodical hunt. Kesha felt relief, real and muted. The relief was not because she expected an easy answer. It was because she now had someone who knew how to read the maps she had been collecting in solitude. There was, however, a moral hazard in relief. in receiving support, because it meant making the work public in new ways. It meant subpoenas, discovery, and the slow, public excavation of a private life. But that had always been a part of the calculus. To reclaim the ledger, one sometimes has to invite the lights. They agreed to begin with Cross Holdings formation records, then follow any amendment trail and see what banks showed the company as having as beneficiaries. If the trail led overseas or into shell entities, the work would need to be juridical and patient. If it led to a simple miscommunication, then it would be easier, but they would accept that too. The point, Yvonne said simply, was to let facts, not charm or cruelty, decide the outcome. As they parted that evening, the city around them felt both thinner and more promising. Keisha walked back to the small apartment she had kept during the marriage for the night she spent working. It was a place of old notebooks and a lamp that flickered like a slow heartbeat. She knew now she was not as alone as she had thought. That was a dangerous and powerful thing. The next morning, the court docket listed additional filings and a notation of a motion for an accounting. An accounting, explained in plain language, is the court's order to have the financial records laid bare, who has what and how it was acquired. If the judge granted an order for an accounting, it could require Damon and any associated entities to produce a detailed list of assets and transfers. It would not immediately unlock every locked door, but it would be a procedural sharpness that could cut through obfuscation. But procedures take time. In the scale of a life, time is measured differently. Keisha had spent years in the background sort of a life. Litigation would now ask for attention and patience. The possibility that Cross Holdings LLC had been amended to remove her months before the divorce filing was a knot. To untie it required more than one woman with a folder. It required the kind of team Yvonne could assemble: investigators who could subpoena formation records, a paralegal who could compare timestamps, an accountant who could trace the $47,000 in any corresponding movements. At the midpoint of the week, news trickled that another document request had been filed. Whitmore responded with a motion to limit the scope, citing proportionality and the burden on his client. Keisha watched the wording with the wariness of someone who knew how lawyering can be an art of pause. Objections are often not expressions of truth but of strategy. Judge Okonkwo, who had already shown attention to the certainties of the ledger, scheduled a hearing to determine whether the accounting motion would proceed. The courtroom on the day of the motion read differently than it had during the initial testimony. It hummed with preparation. Lawyers shifted files. The public sat in a different posture, as if expectation had a weight to it. Keisha felt her heart working under her ribs in a rhythm that had nothing to do with anxiety, and everything to do with readiness. She was now part of a process that required both patience and speed. The motion hearing consumed the morning. Whitmore argued with the calm efficiency of someone skilled at making legal friction look like common-sense restraint. Yvonne, who had now entered as pro bono counsel and filed a short, precise reply, argued for the relevance of the accounting. She explained plainly what an accounting could show, whether assets had been moved, when transactions occurred, and who stood to benefit. The judge listened, eyes steady, and asked pointed questions that suggested a mind less interested in theatrical flourishes than in evidence. In the end, she granted the order for a limited accounting, a careful, significant middle ground that would require the production of certain records within a definitive time. The judge's ruling changed the practical terms of the fight. It did not guarantee an outcome. It only insisted that more paper be made available for scrutiny. That, in itself, was a kind of reprimand to a defense that had assumed that charm and posture could substitute for clarity. Keisha felt a small private vindication. The law had not yet rendered judgment, but the court had recognized the need for transparency. The files that would come back under subpoena might be dense, redacted, or oblique, but they would also be records, timestamps, signatures, and bank routing numbers that could not be flattered into different shapes by a confident smile. As documents began to arrive, some professional in their completeness, others sloppy and rushed, Yvonne's team began to parse them. The first returns contained corporate minutes, emails Bates-stamped, and a set of formation documents for Cross Holdings LLC. The operative question, the one that sat heavy in the air, was whether an amendment removing a spouse as a beneficiary had been filed before the petition for divorce. If so, the naive explanation that asset movement was random or benign would not be plausible. But parsing legal filings is an exercise in patience and humility. Amendments can be legitimate. They can also be vehicles of concealment. The difference is found in context. Dates aligned with a pattern of transfers, a signature that appears to have been forged or executed without proper authority, a routing that points to offshore accounts. None of this was a headline. Much of it was the slow, repetitive work of tracing a story through numbers. When Kesha and Yvonne sat down to review the production together in a small conference room, the evidence began to stitch itself into a clearer fabric. There was an amendment filed 6 months before the divorce petition that removed a named beneficiary from a key holding entity. There were wire transfers labeled with innocuous descriptions that led to accounts whose titles did not map cleanly to the public company, and there were email threads that showed someone, not only Damon, but a number of people in his inner circle, discussing restructuring in a way that suggested anticipatory planning. Kesha read them with a mixture of revulsion and a fierce rising clarity. Each piece of paper was not just an object. It was an armature around which motives and timing took shape. The narrative of erasure no longer felt like a metaphor. It was a sequence. Yvonne looked up from the laptop, her face illuminated by the glow of the screen. "This is not conclusive on its own," she said, careful as always. "But it's enough to convince a judge to look harder. We can move for supplemental production and an accounting that traces the beneficiaries. If we find transfers to accounts that match cross-holdings, and if the amendment predates the petition, we can show a pattern." The sense of forward motion was intoxicating. It was work, not spectacle, and it required both time and nerve. Kesha understood that, but also felt something else, a bracing hope she had not permitted herself in years. The hope was not naive, it was tactical. She was building a case with paper, witnesses, and the patient accumulation of fact. Hours later, when the lights in the small room dimmed and the courthouse emptied, Kesha stood at the window and looked out at the city. In the reflection of the glass, she saw a woman not defined by a laugh or by a public persona, but by a stack of documents and an unshakable insistence on being counted. Outside, the world moved on, but inside she had started to change the terms on which others would judge her worth. The story, however, was not yet in its final chapter. There were hearings to come, motions to reply to, and a set of discovery returns that would demand relentless attention. Damon had stopped laughing in court. He had not yet disintegrated. The fight would be long and circuitous, and the next moves would require evidence that moved beyond a single transaction to a pattern of concealment. When Kesha closed her folder that night, she held it like a talisman. It was not fame or revenge she sought. It was the restoration of what was recorded as hers, and the recognition that the work she had done deserved to be acknowledged in law as well as in life. The brief respite of a judge's order for an accounting had changed the conversation, but it had not settled accountability. The next morning, as they prepared for the filing that would ask the court for deeper document production, Yvonne asked one careful question. "Are you ready to let others read these pages?" Kesha thought of the nights she had hidden drafts under her mattress, of the moments she had decided to keep working rather than argue, and of the people who had told her to accept the settlement. She nodded. "If we do this," Yvonne said, "we follow the paper. We do not presume motive beyond what the records suggest. We let witnesses speak. We keep your dignity intact." Kesha had kept hold of her dignity through years of being spoken over. Now she felt the beginning of a different thing, a legal process that might translate truth into remedy. The path would be public and slow. It would be exacting. But as she walked back into the courthouse, folder in hand and steps steady, she felt a small, defiant certainty. The silence she had carried for so long was not empty. It was evidence waiting to be read. Documents kept arriving one after another, the courthouse printer's hum turning into a small, inexorable drumbeat. Each packet that Yvonne's team fed into their parser felt like a spare piece of a mosaic settling into place. Formation certificates stamped with state seals, amendment trails with timestamps that matched the months before the separation, bank reconciliations with odd intermediate accounts. The discovery returns were not cinematic explosions. They were patient, granular disclosures, and in their accumulation, they were devastating. If you're watching from anywhere right now, drop where you're watching from in the comments and hit subscribe if you love courtroom comebacks. Stay with this one. The best part is still coming. Kesha read with the same care she had used on every page up to that point. Where another reader might skim, she found herself noting marginalia. Who signed what and whether the signature was the same handwriting as a known email sign-off. The exact dates of amendments and whether they preceded or followed particular wire movements. Yvonne's paralegals worked like archivists, and an accountant turned the ledgers into a narrative you could follow. Funds moved from an operating account into a newly formed Cross Holdings LLC, then routed again into accounts whose titles matched a nominee company list. The pattern wasn't one isolated transfer, it was a choreography. One return in particular landed with the force of a small confession. An amendment to the operating agreement for Cross Holdings LLC had been filed, and its effective date was 6 months before the complaint for divorce. The amendment removed a named beneficiary line that, when compared with an earlier version of the document and the SBA file, made clear that someone had altered the distribution profile of a holding structure tied to the company's equity. The amendment's filing stamp was precise. Later, the bank records captured an outgoing wire from the main company account labeled distribution with the same timestamp sequence that showed money moving into an account aligned with Cross Holdings. Yvonne spread the cross-section on a table and pointed quietly to an email thread. "Look at this," she said. "This is not circumstantial. This is coordination." The thread included a terse message from a company CFO type to a trusted associate. "Finalize Cross Holdings today. Clean up the member list." It was not an admission of crime, but in the context of the timing it read like preemptive sheltering. What made it harder to defend was the way the correspondence threaded Keisha's name through the fabric of the enterprise. Not as a marginal note, but as substantive labor. Julian Cortez's emails, produced in discovery, read differently on paper than they had when Kesha first read them aloud in court. There was a brief exchange where Julian thanked her for keeping the investors calm and included notes about the operational rollout she had shepherded. There was one line where he explicitly referenced discussions with Kesha on founder terms, which Yvonne noted as the kind of language that, when paired with formation filings, reduces the room for plausible deniability. Damon's camp pushed back with familiar moves, motions to quash, objections citing burden, and the old tactic of asking for narrow interpretations of relevance. Whitmore made calibrated arguments about proportionality and discovery, the sort of measured rhetoric designed to drain momentum. But the judge, steady and deliberate, had already signaled willingness to let the papers speak. Early rulings had left the route for deeper accounting open, and now, with the supplemental production in hand, the avenue to a final hearing began to sharpen. The hearing Yvonne moved for was not a theatrically staged showdown so much as the law performing its slow arithmetic. On the morning it convened, the courtroom filled with the kind of concentrated attention that had nothing to do with fashion and everything to do with stakes. Damon arrived in the same composed way he always had, but the polished surface had tiny fissures showing at the edges. Whitmore sat ready, but his neat certainties had been interrupted. He was now, in part, a man who had to explain movements on paper. Yvonne's presentation that day was surgical. She began not with invective, but with a timeline, formation date, amendment date, wire traces, emails referencing cleanup and move to Cross Holdings, the lack of repayment trace for the $47,000 personal loan, and a clear mapping of beneficiaries. She used plain language as she explained what formation documents do. They name who owns what and who benefits if an entity is distributed. She showed the judge the amendment that removed a beneficiary 6 months before the divorce filing and then put up the bank entries showing funds leaving the main company and passing through the holding company's account. In the gallery, people leaned forward. The documents were not scandalized in their tone. They were precise, dotted with routing numbers and file stamps, the quiet language of finance. But financial language, when assembled, can do what accusations cannot. It proves sequence and intent in a way that resists charm. Judge Okonkwo listened with the same calm that had marked her earlier decisions. She asked pointed, clear questions designed to cut through the fog. "Ms. Baptiste, who executed the amendment? Do the bank records show the funds moving to Cross Holdings?" Is there any documentation showing a repayment of the $47,000 to Ms. Morrison? Yvonne answered with the evidentiary clarity lawyers learned to prefer to flourish. The answers were factual. They were lean. They left the judge room to apply principle to pattern. At a turning point in the hearing, the judge directed the court clerk to mark a particular page for the record, the amendment removing the named beneficiary. She looked directly at Damon as she did it. The room seemed to contract. You could feel the attention settle into the moment like a physical presence. Then the judge turned and asked the question that would make or break a performance born in charm. Mr. Morrison, did you authorize this amendment? Damon's response was slight, measured. I believed it was executed as part of a corporate restructuring. I was not involved in every filing. That was a classic defense, a claim of non-participation expressed as plausible ignorance. But there were emails with his signature, a CFO's certification, and a bank chain of custody that tied his executive's actions into the same coordinated timeline. Yvonne rose to cross the question with a kind of calm ferocity. She approached the exhibits and, without theatrics, asked Damon to point to emails that bore his name, to acknowledge the wire that moved funds into Cross Holdings, to explain the finalized Cross Holdings email and his contemporaneous calendar entries. Under oath, his memory frayed. I relied on counsel and staff, he said at one point. I do not recall signing every document. The judge did not need performative thunder. She simply let the silence sit after that answer, the same way a tide leaves wetness to mark where water had been. Then she spoke. There is a difference between restructuring for legitimate business reasons and taking actions that remove a spouse from beneficiary positions in anticipation of divorce. The timing here is troubling. Troubling was a judicial understatement. In that way it carried weight. The judge ordered further accounting and indicated she would consider sanctions if obfuscation was found. She reminded the defense of the court's power to demand full disclosure and to hold parties accountable for concealing assets. Her language implied consequences that could move beyond the civil sphere but made no promises. A careful, realistic calibration in keeping with the court's authority. What followed blew away the last of Damon's performative composure. Under the pressure of document-by-document dismantling, small contradictions accumulated into a larger picture. An internal memo that had once been dismissed in deposition as an administrative note, now read in context like premeditation. A chain of emails to a corporate counsel asking for member adjustments took on a different cast when aligned with funds shifted to cross-holding accounts. Each clarification removed the distance the defense had tried to maintain between action and actor. Where memory had been offered, records tightened the possibilities. When the judge spoke the phrase the press would later quote, she did so in that exact careful voice that leaves no room for caricature. Removing a spouse's beneficiary status in anticipation of litigation, she said, is a serious matter. That conduct can amount to theft of marital assets, and this court will not permit intentional concealment. It is important to note that the judge did not pronounce criminal guilt. Instead, she labeled the act in the context of civil accountability and warned of possible criminal referral if concealment continued or if the accounting proved false. The rhetorical line between civil and criminal remedies was respected. What the judge did was use the full seriousness of the court's tone to signal that concealment would not be tolerated. After the hearing, in a small chamber just off the courtroom, the judge issued a written order, an accounting within 30 days, production of all formation and amendment records that touched Cross Holdings within that period, a finding that the court would award a presumptive share unless rebutted, and an initial provisional award of 50% of marital assets and attorney's fees in the amount of $200,000 payable within 60 days, subject to final accounting and adjustment. The order also included a pointed admonition. Any party that continued to obstruct discovery risked contempt and potential referral for criminal investigation related to concealment. The phrasing echoed the earlier oral warning and made the consequences concrete without leaping to criminal adjudication, preserving the boundary between what the court could do then and what might follow later. The reaction in the gallery was muted. Legal victories in public are often quiet before they become loud. Damon sat like a man who had been flayed of pretense. Whitmore's jaw tightened. Kesha, who had expected to remain composed, felt a rush through her that mixed relief with a fatigue that had the weight of years. The order did not mean instant restitution. It meant that the machinery of justice would now pry open accounts and disclose beneficiaries with the force of law. In the weeks that followed, the accounting work became granular and relentless. Subpoenas that had once been theoretical now produced bank reconciliations that filled binders. An independent forensic accountant, engaged by the court and available through Yvonne's connections, traced the trail of funds with the mechanical clarity of someone who reads numbers the way poets read lines. One reconciliation showed that funds routed through cross-holdings had been distributed to accounts in the names of nominee entities, and that a portion of the distributions had been used for items that matched Damon's public expenditures: home renovations, investments in ventures outside the marriage, and transfers to accounts in names that did not map to Keisha. Whitmore argued, as expected, that such transfers were legitimate business planning. Yvonne countered that legitimate planning does not involve removing a spouse's beneficiary status months before a separation and routing funds through nominee accounts. The court's independent expert flagged anomalies and requested more precise reconciliations. The cycle was technical and slow, and each item had to be accounted for in a way that a judge could evaluate. Then came the final hearing. It was the moment toward which all this accumulation had been moving, not because evidence magically transformed into judgment, but because the court would now have to weigh the assembled record and exercise discretion. The courtroom that day hummed with a different atmosphere, resolute, sober, and saturated with the quiet gravity of a decision in the balance. Yvonne presented a binder that read like an indictment of maneuvering: the amendment removing the beneficiary, the wire transfers, the email urging cross-holdings formation, the lack of repayment for the $47,000, and the reconciliation showing distribution patterns. She did not aim to inflame. She aimed to demonstrate a consistent sequence of acts. She called an accountant who testified to the traceability of the transfers and to the practical meaning of the amendment's timing. She called a corporate filing specialist who walked the court through the formation and amendment record and explained, plainly, how a beneficiary line functioned in practice. Damon's defense attempted to sow doubt by pointing to the legitimate uses of holding companies and the business necessity of restructuring for investment reasons. But the narrative gap, why a spouse would be removed as beneficiary months before divorce, hung in the air, noisy in its implication. Whitmore tried to redirect the judge's attention to the commercial rationales, but the judge had already been given the materials needed to assess those rationales against patterns of movement. When the judge addressed Damon directly, the scene tightened. "Mr. Morrison," she said, "there is a pattern that suggests anticipatory action to place assets beyond the reach of marital distribution. Can you explain with evidence why your actions were necessary and not intended to avoid a fair division?" Damon's replies came in the measured cadences that had served him in other rooms, but under oath they had less purchase. He offered explanations: restructuring, investor demands, tax efficiency. Each explanation required contemporaneous documentation to substantiate it. Where the records existed, they did not align with his claims. Where he claimed reliance on counsel, counsel's emails showed directives and acknowledgments that undercut claims of ignorance. At a climactic exchange, Yvonne held up two documents and asked for a straight bridge between them. "Here's the amendment removing the beneficiary. Here's the wire to cross-holdings. Who benefited from that wire?" The room held its breath in that particular legal stillness. Damon looked away. He attempted to answer, and an undercurrent of defensiveness pushed through. His voice, which had previously had the cool assurance of a practiced storyteller, now faltered in the face of accumulated specifics. Judge Okonkwo's summation that followed was the narrative instant the title promised. A courtly, plain pronouncement that framed the conduct as a deliberate pattern intended to frustrate the fair division. The judge used the phrase, "deceptive transfers," and in the measured sentence that would headline later reports, described the removal of the beneficiary with the rhetorical force of law. When a party alters beneficiary status in a holding structure in the months before filing and moves funds through nested entities, the court must evaluate whether those acts were intended to conceal marital assets. Here the documentary record and the timing leave the court with little doubt. The judge awarded Kesha 50% of the marital assets and ordered the $200,000 in attorney's fees payable within 60 days, alongside a full accounting to be completed in 30 days. The judge also included a stern admonition about contempt and the potential for criminal referral if concealment persisted or if false statements were made to the court. She was careful to underline that these were civil remedies and that any criminal matters would require separate proceedings based on distinct standards of proof. Her ruling balanced seriousness and restraint. It restored with the tools the law provides. There was no gloating. Kesha, asked later by a reporter how she felt, spoke in a voice that had the early mornings and late nights braided into it. "This was about records," she said. "It was about the paper that shows what we did and who did it. If anyone else is in a position like mine, keep your files, keep your receipts. Tell your truth and find people who will help you read what the paper says." Reporters shuffled for quotes. Friends hugged quietly in corners, and Yvonne and Kesha embraced in a brief, private way that said more than words. Damon left the courthouse flanked by counsel. His public image would endure in certain circles, but the court's order had stripped away the color of effortless dominance he had long enjoyed. It did not, and could not in that moment, rewrite every public narrative, but it did place legal weight behind Kesha's claim of contribution, and it began the work of restitution. The weeks after the ruling were measured in practicalities. Distributions were adjusted, bank reconciliations continued, and the court monitored compliance with the accounting order. Whitmore filed motions to stay certain enforcement steps, and Yvonne responded with precise evidence-driven filings. The machinery of enforcement is often an unromantic set of exchanges, but it had real consequences. Funds that had been stowed were now being drawn into the light, and liability for fees was made concrete. Kesha did not return to a life of triumphalism. Instead, she began the careful work of rebuilding. She took the financial settlement not as an end, but as seed money with intention. Months later, small signs of a new chapter became visible. A modest office lease in a neighborhood of mixed uses, a framed copy of the original SBA business plan hung not as a relic, but as a reminder, and a desk where someone had placed a small potted plant that would grow slowly, green, and persistent. She founded Morrison Financial Consulting with a clear ethos. Help women who had been erased by partnerships and marriages read their financial histories, claim records, and begin again. The firm started lean. A receptionist who greeted clients by name, an operations manager who had once been a vendor in Kesha's earliest days, and a small pro bono fund for those who could not afford help. Most important, Kesha instituted a mentorship program modeled on the one Yvonne had given her. Legal clinics, document workshops, and a network of volunteer accountants and paralegals willing to dig through filings and teach others how to read their own paper. One of the first hires was Camille, who brought institutional memory and a battered, irrepressible optimism. Isaiah, too, took on a role coordinating technical reconstruction of digital records for clients who had lost access to old accounts. The office was small but purposeful. It was a reclamation not just of funds but of knowledge. They held workshops on how to archive emails, how to secure backups, what formation documents reveal, and when to seek counsel. They did not promise legal miracles. They taught preparation and the practical reality that records matter. Kesha's public statements after launching the consulting firm were careful and generous. She spoke about restoration, not revenge. She told the story of being laughed at in court, a line that became a part of her public truth, but she always paired it with the quieter detail that her silence had never been empty, it had been full of documents. She often repeated a line she used in client workshops. Silence is not always absence. Sometimes it's evidence. There were practical ripple effects beyond the firm. Yvonne's pro bono network thrummed with new energy. Attorneys who had won small victories in their practices saw in Kesha's case a template for chasing complex formations and house of cards transfers. A series of community events organized by Morrison Financial Consulting brought dozens of women into rooms with notebooks and printed bank statements, and over the course of days they learned to trace wires and understand operating agreements. The mood at those events was part grief, part pragmatic resolve, and part the steady work of rebuilding trust in oneself. Kesha also took care to restore the relationships that had mattered and to leave behind what had been damaging. She reconciled with some collaborators and cut ties with those who had perpetuated erasure. She had no appetite for public humiliation. Her goal was practical restoration and to make sure others had the language to describe what had been done to them. There were lingering complexities. The judge's order, while decisive, did not erase the emotional labor it took to navigate discovery and public scrutiny. People asked whether every woman in Kesha's position should represent herself. Kesha, wise from hard experience, always answered with a cautionary clarity. I prepared because I needed to, and because I had no other options. That path is not for everyone. Find counsel, learn the documents, use professionals when you can. This story is about preparation, not prescription. Months after the order, when the immediate legal dust had settled and the office's little plant had grown 2 new leaves, Kesha stood in a small room filled with women who had come because word had spread about her workshops. She wore a simple navy blazer, mended at the cuff, and the gesture was now intentional, a reminder of where she had come from. She told them not a dramatic catechism, but practical truths. Keep records, photocopy business plans, preserve emails, and consult someone who understands formation documents. She emphasized dignity in the process. Her voice had the steadiness of someone who had learned to translate hurt into a vocabulary courts could hear. At the end of one workshop, a woman in the back hugged Kesha and whispered, "I didn't know where to start." Kesha replied softly, "Start where you can. Start with what you have and bring people who will help you read it. The paper is patient, but it needs readers." Outside the courthouse where this all began, the world had not stopped spinning. News cycles moved on. New scandals and new court fights took up space. But the small particular truth of Kesha's case persisted. A woman's quiet labor had been recorded in emails and ledgers, and when those records were assembled and read, the law could respond. The title that had once felt like a grim sentence, "He laughed when she walked in," had been reframed by the record. Her silence, the silence of stored documents and time-stamped emails, became the mechanism that undone a long facade. In a final private scene, Kesha sat at her new desk late one evening, the office lights casting a soft pool across a stack of files. She took a faded copy of the SBA business plan from the wall and slid it into a new binder. There was no triumph in the motion, it was a settling of account. She thought of Yvonne, of Camille, of Isaiah, of the paralegal who had stayed late to highlight footnotes, and of the countless unseen people whose small acts of labor and courage had threaded together into that day in the courtroom. When a reporter later asked whether Kesha felt vindicated, she paused and chose a word that felt more precise than vindication or revenge. "Restored," she said. "I was restored to the record of what I did. That makes it possible to move forward." That forward led in time to a modest but meaningful measure. Kesha's firm started a scholarship for women seeking legal help to reclaim records and offered free clinics in neighborhoods where access to legal and financial education had been scarce. The small plant on her desk grew and eventually had a branch long enough to hang a note on. "Keep records." He had laughed when she walked in, but the silence they'd assumed was empty had been a repository of truth. Quietly, and with the legal machinery of accounting and disclosure, that silence was read and translated into restoration. It became, in the arc of the courtroom and the slow algebra of evidence, his worst nightmare. Not because he was humbled in a spectacle, but because the papers he had relied upon to preserve his narrative told a different story when someone with patience and courage read them aloud. If Kesha's story moved you, leave a comment below. Share this with someone who needs encouragement, and subscribe for more stories of quiet courage and careful justice.